at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the Massachusetts Appeals Court oral argument for June 2nd, 2020. My name is Mary Thomas Sullivan. Today, your panel will consist of me, Justice Amy Blake, and Justice Joseph Ditkoff. This is a virtual sitting located in a virtual replica of our courtroom at the Adams Courthouse. We are displaced from our courthouse, named for John Adams, the author of our state constitution, the oldest written constitution in the world, and the blueprint for the United States Constitution and the Bill of Rights. John Adams was nothing if not a creative visionary, although I'm not sure he would have envisioned this. A deep debt of gratitude to the clerk of the appeals court, the staff of the clerk's office, the court administrator, and all the judges and law clerks whose creative vision and seamless collaboration have made this remote sitting possible. We will be hearing 6 cases today, and we will take a break after the 3rd. If you are watching remotely, the screen may go to black, but you can just stay online and we will return with each successive case until we have completed our sitting. Even though we are on live stream, we will follow the same rules and customs as in the physical courtroom. Each side has 15 minutes to argue, and the justices will ask questions. There will be no rebuttal. Only one advocate may speak at a time, and the session clerk may mute other advocates until it's your time to speak. We will also display the countdown clock. This proceeding is live and being recorded. Anything said during the proceeding will be heard by all of those observing and be part of the record, just as in the physical courtroom. If there is a technical problem with the Zoom session or any participant, the session clerk or justice may announce that there is a problem with the meeting, and we will suspend until we can fix it. So, with those preliminary remarks, we'll call our first case for which counsel is present. And our first case is 19P1275, Commonwealth versus Robert W. Shanahan. Counsel, you may proceed.
Good morning, Your Honors. May it please the court. My name is Valerie De Palma, and I represent Robert Shanahan. I'd like to start with the first argument in the brief, the validity of the defendant's implied waiver of the right to counsel. This court reviews these waiver claims under a de novo standard, and giving deference to findings of fact to the extent there are any. A defendant may impliedly waive his right to counsel if he refuses without good cause to proceed with appointed counsel. There are no prescribed questions for this waiver, unlike in other contexts. However, the record must reflect that the defendant understood the magnitude of the undertaking, the perils of self-representation, and the seriousness of the charges and penalties that he faces. In this case, Mr. Shanahan did not receive any such warnings, and the record does not reflect that he understood the consequences of his decision to proceed pro se.
Normal remedy for this kind of problem is having a new trial with counsel for the whole trial, but your client got that. So what remedy could we give for this error, assuming it is error?
Well, I mean, I think that I believe that in other cases where this has occurred in a pretrial context, new trials were ordered again. I agree that, Mr. Shanahan did have counsel counsel was reappointed at trial, but I believe in the case of, Clemens, I'm sorry, I would have to look back at the cases where the violation occurred at a suppression hearing, or in this case, it was the pretrial proceedings, but.
Well, if it was at a suppression hearing, we'd give someone a new suppression hearing with counsel. Are there any of the hearings where he was unrepresented that you would think would have to be redone?
No, Your Honor, it was the discovery, it was the pretrial period. There were status conferences, and he did represent himself during those, and I believe, filed motions and was successful at moving to dismiss one of the charge of armed assault in a dwelling, which was later re-indicted. But what he did lose out on was investigation of his defense, which is the subject of his ineffective assistance claim. But if the court wishes, I can identify the cases where the violation occurred and in the pretrial context and submit them.
Counsel, remind me, was your ineffective claim brought as a motion for new trial?
It was, and it was litigated and denied without an evidentiary hearing.
That's what I had recalled.
Yes.
If your argument is that the ineffectiveness was with respect to the investigation, is there an obligation on the defendant to show that investigation would have provided information that would have been material to the outcome of the trial? And if so, was any such information provided to the motion judge?
Yes, Your Honor. Mr. Shanahan submitted an affidavit from an eyewitness identification expert discussing the many issues, complicated issues.
I'm aware of that, but how do you deal with Gomes 2?
Gomes 2 is distinguishable because the court found that in that case, the eyewitness identification expert's testimony would have bolstered some of the Commonwealth's witnesses, and therefore it was a proper tactical decision not to to have sought an eyewitness identification expert there.
But is that what Gomes relies on? I thought that Gomes had said that they didn't expect ordinary fallible counsel to go the extra mile of additional evidence or experts in Gomes.
Yeah, my recollection was they did state that it would have been, in Gomes, my sense was in Gomes 1, they did remand it for the hearing on whether, eyewitness identification testimony would have been made a difference. But I recall from the decision that the court noted that the expert testimony would have actually been hurtful to the defendant. So, but yes, and they said it would have been like, I'm sorry?
This case was tried before Gomes 1 was issued, right?
No, it was tried just after. Gomes came out, and then 2 weeks later, Mr. Shanahan was tried. And in fact, the jury received the provisional instruction that, and I would also point out the case of Ayala, which is a fairly recent case from the Supreme Judicial Court. In that case, the court addressed a claim that counsel was ineffective for failing to have presented eyewitness identification testimony. And in that case, they held that he was not, and they noted in a footnote that the case was tried in 2009 and that the study group report was not available, and they noted that Gomes was not available. And conceitedly, 2 weeks to, that's not a lot of time to process the Gomes case, but the study group report had been available since 2013, for 2 years, and that's an authoritative document. All of the research in my brief derives from that report, and it certainly was a very substantive and discussion of eyewitness identification.
So in Ayala, though, the court held that trial counsel was not ineffective, correct?
Right.
Because they had vigorously challenged identification during the trial. So in this case, what should the attorney have done? But for the expert witness, I understand that argument. What else should he have done in your view?
Well, in addition to eliciting testimony that would have corresponded to the many factors that undermine eyewitness identification evidence, he also should have moved to exclude the Facebook identifications.
Why would that not have come in?
Why? Because they were extraordinarily suggestive. When the victims in this case reported the crime, they were not sure who had attacked them. And I would recommend the 911 call to listen, for your honors to actually listen to it, because there was some dispute below about what was said. But the victims did not know who had attacked them. Colleen Cunningham states many times, "I have no idea who it was." And she was in the best position to see. After all, she wasn't being attacked. She was observing it. Mr. DeCamp says at one point during the call to the dispatcher, he says, "I thought it could be Rob or somebody I don't know," something to that effect. He does not say for sure who this person is. They then speak to the first responder, Officer Morris, and he states and testifies that the name Rob was not mentioned until after Mr. DeCamp was taken to the hospital, when he was speaking to Cunningham outside. And she told him they thought it could be this guy, Rob. They didn't know his last name. And in his presence, she calls their friend, a mutual friend, to confirm Shanahan's last name. During the trial, they testified that they knew who it was, but I would submit that their memories by the time of trial were very contaminaminated by a lot of very suggestive post-event information. Excuse me?
Justice Ditkoff?
Well, Counselor, I want to make sure I have all your claims of ineffectiveness down. I've got that you believe counsel should have called an expert, that he should have moved to suppress DeCamp and Cunningham's identifications, that he should have objected to the opening and the close. And then you said something about eliciting testimony. Could you, if I'm missing anything, please?
Sure. No, that's correct. It's that eliciting in the sense of, and in the expert's report attached to the motion for new trial, she talks about weapons focus and lighting conditions and stress and disguise. The intruder was wearing a hat, and counsel, and again, this is a case of he raised a misidentification defense, but it could have been much more robust.
And these are the things that would be elicited from DeCamp and Cunningham, or from a...
Yes, on direct examination. But my point about the Facebook identifications is that they were, so they had not, neither victim has identified anyone. And in fact, the police TART tape, which is also part of which I had transcribed, the police were actually they were staking out Shanahan's apartment, but they were also actively looking for other suspects fitting the description. That.
Are you by any chance familiar with Commonwealth versus Gallup-Hugh? It wasn't cited in either brief, so if you're not, that's totally understandable, but if you are.
No, I'm not familiar with that, Your Honor.
I don't, please go on.
Okay, I'm sorry.
But before you do, if you could share with us your best case for the proposition that the Facebook ID, which I gather had no police involvement. Is that correct?
Yes.
Okay, what's your best case for the fact that we suppress identifications based on what you would claim to be a suggestive Facebook ID when there has been no police involvement?
The Commonwealth versus Johnson from the Supreme Judicial Court,
Okay.
and then the underlying case Jones, under the common law principles of fairness. And I see I'm quickly running out of time, but I will just say that the mugshot identification from the newspaper, as well as the in-court IDs, were both successive identifications that were tainted by the Facebook identification. And I just quickly mention the argument regarding the lay opinion testimony regarding Shanahan's arrest photos. The victims were not present for that. And they testified, that's the guy, that's Mr. Shanahan, and that's where I hit him, basically. They really amounted to yet another identification. The jury was perfectly able, they were not grainy videos. They were not in a bed. The whole issue in the case was that the guy? And that testimony was, I feel, deeply prejudicial.
How were those pictures authenticated? Were they authenticated by the officers?
By the officers, when they came in as they were in for ID during the victim's testimony and then admitted by the police officers.
One last thing, Counselor, do you have the 911 tape?
I do, Your Honor, and I know it's in the court's file. I can provide it if you would.
Under these circumstances, it's very hard for us to get stuff.
Oh, no, I didn't know whether you already have it, but yes, no, I would happily provide it. And I think it's very important to listen to it because I think you'll hear the victims yourselves and you'll hear, in my view, their deep uncertainty about, who had attacked them.
Yeah, I would very much like to hear it if you can.
Yes, okay, that will be my first order of business. So thank you. And in conclusion, we ask that you reverse Mr. Shanahan's convictions and order a new trial. Thank you.
Good morning. May it please the court, Elizabeth Sweeney on behalf of the Commonwealth. Just for the record, my computer just said my internet connection is unstable. I had an ADA in my office just sprint to our IT director, and he is on his way because with my luck and the way this day has been going, it's going to freeze again. So I just want to make you aware of that. The record reflects that the defendant correctly waived his right to counsel and proceeded pro se with standby counsel for a period of roughly 3 to 4 months in pretrial proceedings. As defense counsel states, there is no particular colloquy, no particular language or words, and no particular piece of information that is essential to waiver of counsel. And I turn this court's attention to the cases I cited, Commonwealth v. Appleby, a 1983 case, which is very factually similar to the case at bar involving pretrial proceedings and waiver of counsel, and also Commonwealth v. Barnes. This court should not weigh form over substance in this issue, where
So
waiver can.
Do we consider the fact, Attorney Sweeney, that he discharged someone before Attorney Glenn? He had an attorney prior to that. Do we have any cases that suggest that we can use that as evidence of knowledge and intelligent waiver?
Yes, in Appleby, there was an issue where the defendant continued to discharge his counsel, and the court stated that you can't pick and choose your attorney. And in fact, in this case, the judge for that pretrial conference date on September 15th said that the defendant was given 2 attorneys who are, quote, the best the bar has to offer. So he was provided 2 very well-respected attorneys on this issue. And he wanted both of them to be, not his attorney and have another attorney reappointed. He was effectively attorney shopping. And it was also on the last day before the final pretrial conference on both cases. So it seems as though, respectfully, the defendant was trying to either delay or stall or just, I guess, shop around to get a different attorney for trial. But as the judge found, he was given 2 very strong, the best the bar has to offer attorneys.
Counsel, did he sign a written waiver?
The record is silent as to that fact. It could not find anything in the record or the court's file as to signing a waiver of counsel. However, that is not dispositive to this issue. That was addressed in Appleby and also in Barnes. And the court can consider the defendant's background, his experience, his conduct in previous hearings, and his representation by counsel before trial, and also whether he was given advisory counsel during the proceeding when he represented himself. And here he did have Attorney Glynn as standby counsel, and in fact consulted with Attorney Glynn he had a few days prior to making his final decision, and the court gave him time to consult him. And Attorney Glynn did not file an objection or raise any issues with the court when the defendant waived his right to counsel. The defendant had a short but meaningful discussion with Judge Nickerson on the issue of counsel waiver, where he discussed alibi issues, DNA results, motions. He understood he was receiving possibly a 20+ year state prison sentence. He understood the role of private investigators, motions, and the role of an attorney, and the importance of discovery. And the defendant filed a motion to dismiss, and he was successful on the motion to dismiss when he had standby counsel. So in reviewing the totality of the circumstances, I suggest the defendant correctly waived his right to counsel.
Let me ask you what I asked your sister, which is, if we disagree with that, what do we do?
So the court reviews it de novo, and as far as a remedy, the remedy would not be a new trial. The defendant would have to show that in some, and I couldn't find a case for this, and that in some way that he was, denied a defense, that his right to an attorney, impugned his ability to properly try this case. And looking at the proceedings and the status states when he had standby counsel and represented himself, and looking at the proceedings and what he filed, as I said, he filed a successful motion to dismiss. He was, asking for certain amounts of discovery. He filed motions on discovery. He received discovery. And if you look at those pretrial conference dates, there's no prejudice. There's no showing that something better could have been done. And that sort of dovetails into the defendant's argument regarding the eyewitness identification issue, and that he was not given a proper pretrial time to explore that issue and did not have.
All right, let's give it a little bit.
It was 9:53 when she froze. Do you think we should ask Attorney Sweeney to sign out and try and sign back in?
I'm going to rely on our clerk for this.
We can remove Attorney Sweeney to the waiting room and have her come back in and restart the timer around 10 minutes.
9:53.
Oh, she just left herself. Okay. Would you like me to pause live streaming or keep it on?
Well, let's take a few moments, at least that we have the benefit of the clock, but we can reset the clock, right?
Yes, we do have a 10-minute timer, which will be okay. Did you want me to keep on the record and on live stream while we wait for Attorney Sweeney?
Well,
Well, let's
why don't we
see.
see?
Brittany,
There
I
we
don't
go.
have the 10-minute timer.
Okay, I can do that. If you
Thank
want to
you.
just input
Sorry.
your, no worries.
No worries. Attorney Sweeney, we're going to reset your clock to 10 minutes.
Okay, I'm sorry. I have my IT director here and I apologize.
No apologies
Not your
necessary.
fault.
We're all doing our best. So when you see the clock reset to 10 minutes, you can start again. There we go.
Turning to the ineffective assistance of counsel issue, the motion judge, who also served as the trial judge, correctly found that the defendant was not provided ineffective assistance of counsel. In applying the Safarian standard, the defendant cannot show that his attorney was incompetent or inattentive, and he cannot show prejudice. The
But we
ordinary
certainly knew at the time of this trial, right, that there was a big movement in the defense bar with respect to witness identification. And in fairness, counsel corrected me, Gomes came out 2 weeks before the trial. But certainly Attorney Glynn was aware that this was something sort of swirling around, if you will, the defense bar and certainly the appellate court. So should he have done more? And is there any area in which you would concede he should have done more?
I agree with the trial judge, also the motion judge, that he was not required to do more. And I turn this court's attention to Gomes 2, which states that an attorney who would make such an effort is worthy of commendation by the defense bar, but the attorney that does not cannot be deemed incompetent. And the motion judge also found that Attorney Glynn could have, as he phrased it, read the proverbial tea leaves of the decision and decided to put on an expert witness. However, the ordinary fallible attorney standard that we're applying does not require the presentation of expert testimony. Here, if you look at his closing argument and you look at the statements by the witnesses that defense counsel picked out, and that he argued inconsistent statements, and that they didn't have an opportunity to see him, and that they were under attack, and that they were misidentify this individual as Rob that they allegedly knew, but couldn't pinpoint him. And also in his cross-examination of the witnesses, he addressed it for the jury. He argued it at length, and then the jury was instructed with Gomes 1, with the provisional instruction. So I would suggest there is no prejudice.
What about the Facebook? What about the Facebook ID?
So defense counsel claims that there should have been an objection to the Facebook identification. This case is very similar to Commonwealth v. Fielding. It also is somewhat similar to Commonwealth v. Johnson, as defense counsel states. In Fielding, the victim had an opportunity to observe the individual, the defendant, who she did not know. And in this case, they knew Rob Shanahan. And an individual at the scene of the crime showed her a photograph, showed her a Facebook picture, and she identified it as that's him. So in that case, the court upheld that it should have been admitted and that it was a proper identification. Here we have even a stronger set of facts where they knew his first name. They knew his name was Rob. They'd also met him on multiple occasions. They had breakfast with him when they moved furniture. They had him over their house for dinner at one point, and they saw him at CVS. Peter saw him at CVS, excuse me. So they had a longer amount of interaction with this defendant. It's not just a person that they had a passing relationship with. They shared meals with him. So I suggest that the Facebook identification was proper. And the site for Fielding is 94 Mass Ave Court 718. That's a 2019 case. And turning to the defense counsel's claim of ineffective assistance of counsel for opening and closing, the prosecutor just asked the jury to refer to their common sense. The court does permit the Commonwealth to make such an argument and bring their life experiences. The judge instructed them to also use their common sense and life experiences, and they were instructed with the Gomes 1 instruction. And if there are no further questions, I rest on my brief and the decision by the motion judge.
Seeing none, we thank.
Okay, we are live streaming.
All right. The next case is 19P0506, Commonwealth versus G. This is an impounded case, and no proper names will be used. You may proceed, Mr. G.
Good morning, Your Honors. Judge Sullivan, Judge Blake, Judge Ditkoff. I recently, last year, started looking to rectify a wrongdoing as I was a teenager. I feel that there was an injustice caused by what I felt was a wrongful arrest. And I was seeking, as a result, a newly enacted statute that lawmakers on Beacon Hill recently enacted in October of 2018. The incident in which occurred, I am not trying to scrutinize the officer and placing blame for any malicious actions. I do believe he tried to perform his job to the best of his ability, but at the end of the day, there were demonstrable errors that occurred. Ultimately, the DA, which she, as soon as she read the stated facts in a letter that I submitted, you know, again, being a teenager, wasn't aware of proper due process. She looked at it and discussed just throughout the case. So I'm hoping justice will prevail today as far as the events, and hopefully I can get this matter expunged.
I mean, so how do we know that's the case? The docket sheet suggests that it was dismissed on the day of trial for failure to prosecute, which is usually because the witnesses don't appear.
Well, Judge Ditkoff, aside from me swearing, you know, under pains and penalties of perjury of the events that occurred that day, and I'm hoping this is on a, you know, because this is uncontested, I understand. I'm hoping that I will be given the reasonable doubt, or at least what preponderance of the evidence based on the evidence I submitted along with my sworn affidavits, that these were the facts. And I suppose I could have tried to get the 911 recordings from back in 2005, I want to say was when the incident was, but I never attempted. And even if I did, I think it would have been in, pretty much with no success or very little.
And one thing that's concerning to me is that you stated you have the police reports, but you didn't submit them to Judge Brooks or to us, for that matter. Not that you should have on appeal if you hadn't submitted to him, but Judge Brooks had no way of knowing whether those police reports back up what you said or not.
Right, I understand. And the police reports obviously is based on perspective of the officer, and he's not going to, you know, essentially throw himself under the bus. But I believe on the police report, it stated 2 times, and for the actual appeal, I realized that this was past my scope of ability. So I ended up getting some limited assistance with formatting and what have you. But when I initially submit the petition, Mass General Law, Chapter 276, subsection 100K, I figured that this would be in the best interest of justice, and I qualify, giving this to be hopefully a textbook example, as from what I've searched, this is an uncontested law at the state level. And I would like to think that the lawmakers on Beacon Hill intended this new statute for this very reason.
Sir, do you agree that your mother told the police that you pushed her?
I believe she agreed when they were asked. What happened was by the third call,
No, I want to know if you agree, because in your affidavit, you say that, right? You say
Right.
at paragraph 15, one of the other officers asked my mother what happened. She was asked if I put my hands on her, and she responded by stating I pushed her. So if your mother said that to the police, whether it was accurate or not, how is that an error by law enforcement?
That one is not an error, Judge Blake, but there were multiple errors before and after the fact.
But if your mother said you pushed her, that could be an assault and battery, right?
Correct.
It's not up to the police to decide who was using appropriate force, self-defense, defense of another. And so even if you disagree with everything else that the police said, if you acknowledge that your mother said you pushed her, isn't that enough to charge somebody with assault and battery? And then if so, how is that an error by law enforcement? Because I think that's what this case boils down to, that one statement by your mom.
Well, as I learned in life, Judge Blake, timing is crucial and is everything. So while if that was the only incident that occurred, that would have been, straightforward, and I probably wouldn't have applied for this newly enacted statute. But considering the dynamics of this case, and this was the third call after there were already multiple laws broken in which the officer acted arbitrarily upon and did not enforce as a sworn officer to protect and serve, I feel demonstrable errors were made before the fact, which is most crucial, and then as well as after the fact by not, serving justice to the both the victim and the antagonist.
So part of the difficulty we have in reviewing this is that at the time that you brought the motion, your record was sealed. Do I understand correctly? You've since had it unsealed?
Yes, Your Honor. I served in the military. Oh, sorry.
Let's just go one step at a time. So the judge was not permitted to look at the file. So a lot of what you're telling us may be matters that would be revealed if the judge had been able to look at the file. But I just want to share with you that another level of difficulty is for the motion judge and for us, that when there appear to be disputed facts in the record, it can be difficult to say that there was this kind of palpable error by the police, and particularly difficult when the judge is not able to look at the file. Because sealing and expungement are two different things.
Yes, Your Honor, and I understand that.
And I thought a little bit from your brief that maybe you thought he could just open it. And I just wanted to share with you that no, he couldn't do that. It had to be officially unsealed. And then the analysis is to see if the petition falls within any of the categories in the statute. And only if it falls within one of those categories do we reach the interest of justice analysis. So that's the sequence that we have to follow in looking at this.
Yes, Your Honor, I understand. If I may speak though, it sounds like he's not even permitted with my consent to look at the sealed case. Is that correct?
I can't give legal advice, but my understanding is that at the time that the matter was heard, the file was not unsealed.
Right. Yeah, because towards the end, he, as he stated, and he had my permission. Obviously, I hold him in high regard. Judge Brooks was very, very nice gentleman, very professional, very knowledgeable. The only thing that kind of made me realize that this may have been grounds for an appeal was because he didn't take it under advisement, didn't refer to the said statute, which is very new, as you may or may not have read the transcripts.
We have, and he listed all the factors in the statute, went through them one by one.
Okay, Your Honor. Well, so at the very minimal, while I would be seeking expungement from the higher court, if at minimal, I can have it possibly brought back down for further review by the subordinate court or the lower court. That is all, because I know this is a major injustice. It has hindered my ability in the military, not to a great extent, but I have been interrogated because of it numerous times, and questioned my ability to deploy in the past and get a security clearance. I do know that, and people I explain this to, especially in these trying times where police misconduct has come under scrutiny, and both lawmakers and legal systems across the country are starting to realize this. I'm just, pleading for justice. And I know I did everything I could that day to de-escalate the situation. Aside from, the old 1980s movie of RoboCop, I mean, if he was there that day, this wouldn't have happened. But unfortunately, we had a human who I strongly and wholeheartedly believe exhibited multiple demonstrable errors.
Could you list those errors, the errors the officer made?
Yes, Your Honor. In the affidavit.
No, do it now, please.
Oh.
Tell me exactly what the errors were.
Okay, would you like me to cite laws too that he violated, or?
Just tell me what things he did that he shouldn't have done, or things he didn't do that he should have done.
Okay, now the first call, that could have been handled with his discretion. The second call, there were which was stated on the affidavit, which there were allegations of my sister making, physical threats to commit a violent act against my now ex-wife. And that in itself, from my understanding, is a violation of a Mass General law. He did nothing. He just came back the second time and was like,
what should he have done? What was his error? What was the thing he should have done?
To my knowledge, it's a misdemeanor offense for arresting. He should have arrested the person who assaulted my ex-wife. If I could speak the name, is that correct? That's
You
not.
cannot.
Okay.
No name.
Okay.
You know,
Excuse me, Judge Ditkoff. I'm sorry.
we know what you're talking about.
Okay. Yeah. So she should have been arrested that day on the second phone call. And then after, the coordinated acts of terror that followed, unfortunately, led to this injustice in which I feel should be expunged. And even if they were to,
I just want to be clear. You
Okay.
said one error is failing to arrest your sister.
right on the second call I made.
On the second call, are there any other errors that the officer?
After the fact, yes. So after she was beaten and bloody, needing limited medical attention on scene, there in the police report, and I believe I did submit that as evidence into the along with the brief and appendix, that there would be a follow-up to put an APB or something to that, or arrest her for the violent criminal acts that she committed. And to my knowledge, and I believe this is 100% fact, there was no follow-up. And at the end of the day, I feel the officer acted arbitrarily in his actions. And while I know it wasn't intentionally malicious towards me, he was essentially, I'm gonna use fed up after the third call.
Let me just make sure I get this. So you're saying after the third call, the officer should have taken steps to find your sister.
After the second call, I believe, yes, after the second call, I believe he should have arrested her based on the criminal acts that he, that were stated.
So the first error is not arresting your sister at the second call. And the second error is not trying to find her, arrest her, deal with her after the third call.
Yes, Your Honor. But obviously, as far as timing being everything in life, I've come to find increasingly more important these days, is after the second call that I made, trying to do everything right, just freshly enlisting in the military. I was scheduled to ship off, I believe, January of the following year. Or it would have been the year after that, I think, because I graduated in 2006. My apologies. So I did everything that I could to mitigate and de-escalate the situation. That was essentially a cry for help for the officer who was sworn to protect and serve the community to do just that and mitigate any harm to the citizens or residents that reside in the Commonwealth.
Let me just say one other thing that may or may not be useful, but in my previous experiences with the military, sometimes they want to know that a charge like this that's been dismissed without prejudice isn't coming back. And that's something that often the DA's office can provide a letter that can be helpful with the military. I don't know if that's what's going on with you, but that's certainly something that when I was a prosecutor was something that we could do for members of the military.
Right, and I appreciate that, Your Honor. This was in the past. I already enlisted back at the time, and well, it was brought up. My recruiter, I did have to get paperwork showing that it was dismissed, but even moving forward 5-7 years later, it still gets brought up and is still questioned. And I know I wouldn't go through, invest this much time, money, and resources if I, in my heart, didn't believe that this was the right thing to do to set the record straight.
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. I'd like to direct the court back to kind of what Justice Blake was talking about, how this case kind of just boils down to the portion of the defendant's affidavit that says that his mother did tell the officers that he pushed her on the evening of this incident. And I think when we look at the framework for what courts look to determine these petitions and whether to deny or grant them, as the court was outlining earlier, the case needs to fall into one of these 6 categories. And as the lower court mentioned, there's really only one in this case where which might be applicable, and it is the one that the court analyzed at the hearing, which is whether there was demonstrable error by law enforcement. And I think, whereas Justice Blake pointed out, the defendant's mother did make this statement to the officers that was sufficient, at least probable cause for the officers to arrest at that point. And I think, as the lower court mentioned, that just because the incident didn't turn out kind of the way that the defendant wanted to on that evening, that doesn't rise to the level of demonstrable error by law enforcement.
But Ms. Johnson, let me ask you, keeping the fact that you just made, or the point that you just made, there appears that there was probable cause to do other things with respect to other individuals. Does the failure of the police to act as to the other individuals at all impact the probable cause finding, at least for the mothers as the so-called victim of the assault and battery? In other words, is there a balancing act here, or is it simply they might not have got it right on the other ones, but on this one there was probable cause, and so that's enough?
I think it's the latter of what you said there. I don't think the fact that there may have been other people involved in the incident, I don't think that has an impact on the analysis for this case, because here we're looking at whether we want to expunge the record for this defendant and determine whether this record was made as a result of demonstrable error by law enforcement. And here it was not. The Commonwealth would argue.
If he had gone to trial and he had posed a self-defense defense and the jury found him not guilty, or a judge found him not guilty, could he have that expunged?
I think there would be other avenues that he could pursue. I'm not entirely sure whether it would fall into this category here, whether there was demonstrable law enforcement, demonstrable error by law enforcement, excuse me. I believe there would be other avenues to pursue in that case where there was a not guilty, but I don't think it would fall into the framework of this petition here. And as I mentioned, where this statement was made and the defendant did include it in his affidavit, I think that, as the lower court noted and relied upon in his decision, that's enough or that is not enough to meet the standard of demonstrable error by law enforcement.
So one more hypothetical. If the Commonwealth had filed a null pros, would that change the analysis?
I don't think so. I think, again, it boils down to here, the statement included in the defendant's affidavit that the mother told the officers at that point that he had pushed her. I think, obviously, there was an incident ongoing on this evening, but I think here, where that statement was made, that was enough to not meet this standard that there was demonstrable error by law enforcement, even though, like I mentioned, that this didn't turn out the way maybe the defendant wanted on that evening.
I mean, what if there was a null pros that said the prosecutor had, read the defendant's account and realized this never should have been brought? Do you think that would get us there? I know that's far from what we have here, but.
Right, and I think, I mean, perhaps it would make a difference in the analysis for the court, whether they determined that there was demonstrable error by law enforcement. Maybe if this statement included something about what happened with the officers, but I think here we're a little limited as to knowing what was going on with the officers and what if any investigation followed. I think when we look to the facts that we have presented here, that there just wasn't enough to meet the standard to determine that there was demonstrable error by law enforcement, especially where it kind of seems like it was a judgment call by the officers that evening.
Am I right in thinking that your office's file is long gone?
Yeah, and that's the point I was making in my brief, when I kind of did the facts, outline the facts of the incident that evening, where this was a district court case based on the schedule for record retentions. This case file likely was destroyed. And if there are no further questions, Your Honors, the Commonwealth will rest on its brief.
I have none. All
Thank
set.
you, Your Honors.
Thank you both. Commonwealth versus DELACRUZ. You may begin.
May it please the court, Matthew Malm for the defendant, Jeffrey DELACRUZ. In this argument, I intend to address two issues raised in the brief, the first being the admissibility of the defendant's statements, and the second being the duplicative conviction argument. The primary issue in this appeal is the admissibility of the defendant's translated and unrecorded statements, not through the interpreter, but through the police officer who was interviewing the defendant through the interpreter. If the interpreter was not properly acting as a defendant's agent at the time of the interview, then the defendant's purported statements as relayed by the police officer were inadmissible hearsay. Here, the interpreter had a substantial and obvious conflict of interest that prevented him from properly acting as a defendant's agent. He was an agent of the victim, the bank, and also of the customer, an accuser of the defendant, and he had already misled the defendant. He admitted to it in his testimony that he had misled the defendant in an earlier interaction by concealing from him that they were contacting the police.
Is it hearsay in your view solely because it was translated?
Yes, Your Honor. And pursuant to Aiden Soto, because it only came in through the police officer and not through the interpreter, the only way it wouldn't be hearsay is if the interpreter is properly acting as his agent.
So if there was not a language barrier, the statements to the officer would have come in if your client had answered them in English, correct?
Yes, Your Honor. Statements of the defendant, of the
So
party
what
opponent.
should the police officer have done at that moment?
So pursuant to Aiden Soto, which was actually published at the time, he could have either recorded the conversation, which was required by Aiden Soto, or he could have also resolved any issues with what was an obvious conflict of interest by calling in third-party interpreter service, which was talked about in Aiden Soto as well, and which the court noted was, a fairly easily accessible thing, through a phone. So he could have resolved it easily.
Counselor,
Go ahead, Judge.
Go ahead, Judge Blake. Go ahead.
I'm trying to understand, you say that the translator was the agent of the bank. Commonwealth says, no, he was an agent of your client. Is that what this case comes down to, is who the translator was a so-called agent of?
Yes. Whether he was, yes, whether he was properly acting as an agent for the defendant. So yeah, it does boil down to that question. And here it was impossible because of this, overwhelming evidence of a conflict of interest and proof that he'd already misled the defendant.
So this argument is not made at trial and we're reviewing for substantial risk, correct?
Yes, Your Honor.
And was there any indication at trial that the translation that was reported by the officer was incorrect? Mistranslated in any way?
So there was no evidence to that, but that's the problem with an unrecorded interrogation done by a translator, because the people on either side of the translation have no idea what the interpreter is saying to the other person. So they have no way of verifying it.
Except that the theory of the defense, as argued to the jury in the closing, was premised on the accuracy of the statements translated by the interpreter. Because the defense was that the police failed to investigate and failed to take into account that the defendant was not the bad guy in this, it was somebody else. And his statement was, I got the check from somebody else. So where is the substantial risk? There was no cross-examination of the interpreter. There was no effort, as far as I can tell, to challenge the officer's recitation of what was said. Where do we find the substantial risk?
The substantial risk exists in how the Commonwealth used the defendant's statements. And it was a critical part of the Commonwealth's case, because those statements, as the Commonwealth portrayed them in closing, was powerful consciousness of guilt evidence. And I think it's worth it to recite what the Commonwealth said in closing about them. And then it was, his story simply doesn't make sense. And yet he tells Officer Reen, yeah, I got the check from someone named Miguel DELACRUZ. It's for a property that I own in Boston. Okay, cool. Where's the property? Oh, I don't know. You got a check for $7,400 for property you own in Boston. You can't tell me the address? That's ludicrous. That doesn't make any sense. He can't produce straight answers to the questions that he's asked. He doesn't know the address. He doesn't know why he has this check, because the reason he gives for having the check doesn't check out. And weighing against this, if we had taken out the defendant's statements, what you're left is powerful evidence of an innocent man, of a man who went in there with a check that he thought was not fraudulent. And that was valid because he went in there, the check was in his legal name. He presented valid identification in his own name. He willingly put his fingerprint on the check. He waited patiently for 30 minutes while the bank attempted to verify the check. And most significantly, he continued to wait even after he was told that the bank was contacting the account holder. You know, if the person thought it was fraudulent at that point, they would have skipped out. So without those statements, there was powerful evidence of innocence. And that's where the substantial risk is.
What is your best case for the proposition that the Aiden-Soto protocol applies, or the Aiden-Soto analysis rather, applies to a field investigation rather than an interrogation in the police department?
And so in Aiden-Soto, they specifically use the language interrogation or interview. And they make no limitation about whether being out in the field or not. Yeah.
I saw that too. Have you been able to find any cases that follow up on that language?
I have not. I can certainly look again after this argument.
You know, what's different between this case and Aiden-Soto is that there it was a language line. There was no way to figure out who the interpreter was. But here we had the interpreter on the stand testifying. Because there was no objection, no one asked him what exactly was said. Is there any reason that we have to believe that he couldn't have given the same stuff if he had been asked? What did he say to you?
He is asked about the conversation. Sorry, moving my cord. Somewhat in direct examination, and it appeared that he didn't recall much about the conversation. He said, he was explaining to me that he was trying to call somebody because I was.
Counsel, I have that in front of me too, but the question was, why were you assisting with translation? It wasn't, what did he say to you? What do you remember? The question is, why are you assisting with translation? He goes off on this non-responsive answer, but no one ever asks him, what did he say to you? Unless I missed.
Okay, and so I would respond to that by saying, I think that the speculation about what he might have what he could have testified to about this conversation is inappropriate, because the Commonwealth is the proponent of the evidence in this case, of that particular evidence, and they chose to admit it through inadmissible hearsay. I think the only way we can properly determine whether this interpreter could have offered evidence to the statements is at a new trial.
Well, I mean, that would make sense if you'd objected, but you didn't object, and so the hearsay comes in, and the Commonwealth doesn't know they need to introduce it a different way. So how do we get substantial risk without knowing that it couldn't have been gotten from the interpreter?
So the fact that I think it's significant that the Commonwealth chose to use inadmissible hearsay, and they shouldn't be able to escape remand here by the fact that they had an available witness to present, had the witness there that could have presented it, that wasn't hearsay, and they decided not to use it. And I would point again to the other strong evidence of the defendant's innocence. So if there are no further questions on the issue of the admissibility of the statements, I will move on to the argument regarding duplicative convictions or duplicative conviction. And so it's a two-part analysis. And the first step, I think the court has to determine whether the jury were properly instructed on larceny by stealing as opposed to larceny by false pretenses. And it's fairly simple. The question is whether was the Commonwealth alleging a non-consensual taking, that is larceny by stealing, or were they alleging a consensual taking, which would be the larceny by false pretenses. The facts presented here only support a claim of consensual taking. The defendant didn't go in there with a weapon and demand money. He went in there armed only with a check. And the Commonwealth's theory was that he would use that check to take the money out of the bank with the consent of the bank and the customer.
Why does it have to be a non-consensual taking? It has to be a trustatory taking. Why are those the same thing?
I'm sorry, could you repeat the question, Your Honor?
It has to be a trustatory taking.
Trustatory.
Why is that the same thing as non-consensual?
So trustatory is, and I cite a federal case that says a trustatory taking is a non-consensual taking. So it's a sin for that.
Let me give you this hypothetical. At a restaurant, not going to happen for some time, obviously, but pretend it's before all this happened. I'm at a restaurant, I put the money down, and the waiter comes and he takes the money and then he runs off with the money, never turns it in, takes off. That's not a larceny by stealing? I mean, I intended him to take the money, just not then run off with it.
So the waiter would then be taking the money from the restaurant because it was the restaurant's money. So in that case, I think it would be a non-consensual taking.
Well, the restaurant wanted him to take the money too. It's his job to take the money. It's just his job to then not run off with the money.
So I think the victim there would be, well, I guess I'm struggling with determining who the victim is in that.
I mean, I'm not sure it matters because both I and the restaurant consented to him taking the money. We didn't consent to him running off with it. It seems trustatory to me though. I don't know if I could say it's non-consensual, but I may be missing something.
So I guess I would analyze that by saying the victim there was the restaurant, and in that case, that was certainly a taking without the restaurant's consent, because they expect him to go put it in the register at that point. And if he doesn't, then that's not by consent. There's no false pretense used. But I guess that's how I would address that hypothetical. And so then, if the court does accept my argument that this should have been larceny by false pretenses, the court can look to Crocker and its discussion of whether larceny by false pretenses is a lesser included of uttering. And in that case, they said it wasn't.
How do we get there? Don't we look at the case that was tried, not the case that you think should have been tried? I mean, we look at an elements-based approach based on what was charged and what was tried, not on a hypothetical trial.
Yes, and so this case presents kind of a unique scenario that's I think caused by the fact that we have a statute that allows for just charging of larceny, but then there are actually 3 offenses that have to be sorted out at the jury instruction stage. So pursuant to Mills, if he should have been instructed on larceny by false pretenses, then it would be remand for a new trial, because it is essentially an instructional error. But this presents a unique situation because there's a lesser included argument in there. And so it'd be a question of whether it should be remanded, would it be worth remanding at all for a new trial if in fact, based on what the facts that were presented, this would have been a lesser included anyway.
So you're saying your argument comes in on remedy, not error?
I believe yes.
Okay.
And so in that case, if larceny by false pretenses is, if you agree with me on that, attempt takes away the permanent taking element and the reliance on false statement element, and you're left with something that's equivalent to uttering. And I see that my time is up.
Thank you very much.
Thank you, Your Honors.
Counsel?
Good morning, may it please the court. Catherine Leary on behalf of the Commonwealth. I'm going to start first with the police officer's testimony about the defendant's statements through an interpreter of the bank employee. Under Ann Soto, and I agree with the defendant in this case in so much as the fact that because the statements came from the interpreter, the defendant's statements came through the interpreter, they're not the defendant's statements in this case unless the interpreter is acting as an agent of the defendant. And in Ann Soto, there are 4 factors that this court would look at: who supplied the interpreter, whether there's a motive to distort or mislead, qualifications, and were the defendant's actions consistent with the statements as interpreted. I would submit, as I argued in my brief, that Lugo, who was an employee of the bank, was not necessarily an agent of the bank. I think it's important to look at the fact that he began acting as a language conduit for the defendant before.
It doesn't, since an interpreter is a joint agent of the people talking, didn't he at least have to be an agent of the bank when he's interpreting between a bank employee and the defendant?
So the interpreter being a joint agent was under this court's case, the SJC's case law under, I think it was BOSE, B-O-S-E, which is discussed in Ann Soto. I think my reading of Ann Soto, and I could be incorrect, is that used to be they were joint interpreter, and if you agree to use the interpreter, they're kind of an agent of both of you. However, in Ann Soto, I believe you kind of have to make this decision whether the interpreter is an agent of one party or the other. I understand your point, Justice Ditkoff.
I guess I don't get that. If he's has to be the agent of one person or the other, then you'd need 2 interpreters. One to interpret the bank employee or the police officer, and one to interpret the defendant if an interpreter can't be an agent of both.
I understand your point, Justice Ditkoff. I'm not entirely sure what the correct answer is to that based on Ann Soto. I think for the the statements of the defendant to be admissible, he would need to be an agent of the defendant. And as for the statements of party opponent to be admissible, I agree with your interpretation, but I feel constrained by Soto. But any event.
So in general, though, interpreters, whether they be a sole or a joint agent, have an oath at least when we do it in a more formal setting, to interpret fairly and accurately and neutrally. And in this instance, the interpreter withheld information from the defendant. So how do we say, given those facts, that he is an agent of the defendant when he's withholding crucial information? He's not interpreting the phone calls as the teller's making them. He's not telling her he's not telling the defendant what's being said on the phone. So how is he an interpreter for the defendant?
I think when you're looking at, it's not just, I think that could be a factor that weighs against him being an agent of the defendant. I'm not going to say it's not a factor that weighs against it, but there are also other factors that you would consider, whether his qualifications, whether the defendant acted consistently with the statements as interpreted, because I think part of the factors that Soto discusses and whether or not we can really view these statements as the defendants opposed to the interpreters is, was this a fair translation? Here, the translation and the accuracy of it was not contested at trial. And the defendant had the opportunity to contest that. Lugo stated that he is fluent in Spanish and he interpreted everything fairly and accurately. And the defendant's actions of once being informed that these checks are being investigated for their potential fraudulent nature, he said, well, you know, they're from Miguel DELACRUZ, and he gave these phone numbers and tried to contact Miguel DELACRUZ. Even aside, if the court were to disagree with the Commonwealth that based on the circumstance of this case, because he didn't tell the defendant that they were calling the police, there was no objection to this testimony coming in through the police officer opposed to Lugo, who was there to testify at trial. And so there's no substantial risk of a miscarriage of justice. As Justice Sullivan pointed out, the defendant used his statements as admitted through Officer Reen to bolster his defense that he didn't have knowledge of the fraudulent nature of this check in his closing argument. And I would also point to the fact that apart from the defense statements and how the defense counsel used them, there was evidence from the maker of the check that they had no relationship to the defendant, and yet the defendant has his name printed on this check. And I think that creates a reasonable inference that the defendant knew that this was a fraudulent check, that if there's no relationship known by the maker, the defendant necessarily would know that he had no relationship with this realty company. I would also point to
what other evidence is there of knowledge?
Yes, Your Honor.
Let's assume, let's engage in the hypothetical discussion of if there had been an objection and if the interpreted statement had been excluded. What evidence is there of knowledge other than the testimony of the maker? Is there anything else?
Yes, Your Honor. I would point, aside from the testimony of the maker, also the defendant's extreme nervousness, which is relevant on its own, might not be enough, but it's relevant, especially because here, the officer who responded said it was beyond of just being nervous talking to police officer. I thought he needed an ambulance and he was sweating so much. And I think that's in stark contrast, although it wasn't testified whether he was nervous or not by the bank employees, there was no mention of it. So it seems that when the police officers came, that extreme nervousness, you know, that's an inference of being, oh no, my jig is up. Also, I would point to the fact that while the defendant contests this, I think the fact that he requested to cash such a large amount of money opposed to depositing it is relevant to knowledge. And I point the court to Katina 377 Mass 186. It's cited in my brief for the proposition that the request of cash versus deposit a large amount of money is relevant to knowledge of fraudulent nature of the check. And I would also point, my position in the Commonwealth's position is that the defendant's statement, Miguel DELACRUZ, and giving of the phone numbers are not hearsay. Miguel DELACRUZ doesn't need to be translated. That's a name. And the phone numbers are also not hearsay because they're numbers. And the officer said we were given the phone numbers. And then that in conjunction with him trying to call somebody to try to sort out the check also goes to his knowledge. So I think all of those taken together, if we were in a world of prejudicial error, I think that would also be sufficient to overcome prejudice, but we're not in that world. And so for the reasons I already stated, there was no substantial risk of a miscarriage of justice if the court finds that Lugo was not acting as an agent of the defendant. If the court has no further questions on that issue, I would briefly address the duplicative conviction issue. First, there was no error in the judge's instruction of attempted larceny by stealing. The elements of larceny by stealing, well, of attempted larceny by stealing would be the intent to commit the offense and overt act towards the commission of non-achievement, and the in larceny by stealing requires an unlawful taking and carrying away of personal property of another with intent to permanently deprive another person of their property. Here, the attempt to cash a check and take the cash away from the bank is sufficient to establish a trespassory taking of that money from Brooks Pond Realty and to permanently deprive them of that. So that is larceny by stealing. And so therefore, where the evidence was sufficient to support that theory, and the judge instructed on it, there was no error.
I mean, that assumes that successfully accomplishing this would be larceny by stealing.
I'm sorry, I didn't hear the beginning of your question.
You'd assume that successfully accomplishing this scheme would be a larceny by stealing.
Correct, but this is an attempted larcemy by stealing. So he acted with the specific intent to commit that underlying crime of larceny by stealing. So I would point the court to Green, 66 Massachusetts Appeals Court 901. Justice Ditkoff, I know you were the prosecutor on that case. But in that case, while the court didn't specify whether it was larceny by stealing or larceny by false pretenses, I think it's still relevant to show that the act of attempting to deposit a counterfeit check established the intended taking of a property of another. And I think that's sufficient. I think the facts are sufficient to support that here, where he attempted to cash the check and went through great lengths to do so before the non-completion of it.
I thought I lost that case.
Part of it. If the court has no further questions, I'm happy to rest my brief.
I do, just back to Aiden Soto for a moment. Have you located any case where Aiden Soto was applied to a field interview rather than an interview or interrogation at the police station?
I have not. And, you know, I think Aiden Soto has a few propositions stands for. I think we're requiring a recording of an interpreted interview is kind of more the scenario we're talking about, whether or not it's a field interrogation versus at a police station. I would say in this case, it wouldn't have been practicable to record this interview because it's investigatory. The police officer is trying to figure out what's going on and see if, you know, this
Everybody's got a cell phone.
I'm sorry?
Everybody's got a cell phone.
Everybody has a cell phone, but I don't think in the heat of the moment of just trying to figure out what's going on, this wasn't an investigatory, this wasn't an accusatory interview or custodial interview. It was the officer trying to figure out what was going on. And I think in those situations, you know, Aiden Soto, I think, is thinking about when somebody's brought into a police station or not as a fluid situation, but the purpose is to sit down, interview, and really find out what happened, opposed to here, which is trying to get the lay of the land. And I would suggest I haven't found a case that deals with Aiden Soto in this situation as far as recording. And I don't think it would be applicable in this case.
Thank you.
Thank you very much.
All right. Panel satisfied? Yes. Okay. That concludes our hearing in this case. Thank you very much to both counsel. And we will be taking a 10-minute recess and we will reconvene around 11:10.
All right, we are live streaming.
All right, thank you very much. We are now resuming with our fourth case, number 18P12996. Sword number 432172, Doe 432172 versus Sex Offender Registry Board. This is an impounded case. We will be using only pseudonyms. Please, counsel, you can proceed with your argument and identify yourselves for the record as you begin your argument.
Great. May it please the court, Attorney Xiomara Hernandez for the plaintiff appellant John Doe. As you know, the board classified my client as a level 2 sex offender for a governing offense he committed back in 1990, which was about 30 years ago. I'm here today requesting that this court either lower my client's classification level from a level 2 to a level 1, or remand the case back to the Sex Offender Registry Board for another classification hearing. As you see in my brief, I argue that the board actually committed multiple errors. The hearing examiner committed 2 specific errors of fact in the classification decision. First, the hearing examiner erroneously found that my client forcibly raped his then girlfriend in 1990. As you'll see in the record, my client pled guilty to attempted rape. He was not convicted of rape. And additionally, and I know the hearing examiner is not bound by what my client was convicted of, but also could look to the record to see if there's more information there. If you look at the record, the police report had very little information regarding this attempted rape. There was just one sentence that indicated that he raped the woman, which was his girlfriend at the time. The hearing examiner even appeared to be worried about this lack of information that was contained in the record, where he actually issued an order requesting that the board provide him with more information concerning this allegation, and the board failed to do so. Additionally, the hearing examiner erroneously found that my client committed rape in 2006. Again, it's for the same reasons. He was not convicted of a sex offense in this instance. He was convicted of menacing. And also, if you look at the record, again, you'll see there's a lack of information in there concerning this specific allegation, leading the hearing examiner again to issue an order requesting that the board provide it with more information. And if you look at page 144 of Record Appendix 1, you'll see that the order that the hearing examiner issued indicated as follows. Exhibit 4, which the Exhibit 4 is the police report regarding this allegation, doesn't provide comprehensive detail of the incident. So as a result, the hearing examiner wanted more information. And again, the board did not provide it with that more information. As a result of the hearing examiner finding these 2 facts in error, in my opinion, he applied multiple regulatory factors that caused the risk level to be increased or to be 2 versus 1. For instance, the hearing examiner applied high risk factor 2, which is repetitive and compulsive behavior. The hearing examiner also applied risk elevating factor 19, which is level of physical contact. And lastly, the hearing examiner applied risk elevating factor 22, which is number of victims. And if you see in the decision, the hearing examiner seemed a bit conflicted about this case in terms of what level to give my client. On page 78, Record Appendix Volume 1, you'll see that the hearing examiner finds as follows. I find that the mitigating considerations are slightly outweighed by the aggravating factor. So in other words, had the hearing examiner not erroneously applied these risk factors, these high risk and risk elevating factors, and not have found those 2 facts which were found in error, in my opinion, the hearing examiner would classify my client as a level 1. There was also 2 additional errors that the hearing examiner committed in the classification decision. Specifically, the hearing examiner erroneously applied risk elevating factor 9, which is alcohol and substance abuse. As you'll see, my client did submit a letter to the board indicating that he's been drug and alcohol free since 1990. He did attend alcohol and substance abuse treatment while he was incarcerated. And he is randomly tested for drugs since he's a truck driver. He does need a CDL license, so they do randomly test him for that. And just an aside,
Our authority to reduce the classification to a level 1.
I'm sorry?
What is our authority as an appeals court to reduce the level to a 1?
The hearing examiner committed multiple errors, as I indicated. Two of the errors were regarding the facts involved in the case. He found
Right,
that,
but I'm saying, how do we step into the shoes of the hearing examiner? Is it, if we agree with you, isn't it a remand?
well, you could also do a remand, but you could find also as a matter of law that given these errors that the hearing examiner committed and also some other factors that I'll discuss later, positive factors involved in this case, you do have the authority to lower the level on your own.
Right, so what is the case that says we can do that?
Oh, I don't have the specific case in front of me, but there is statutory law. There are cases where the court has lowered class or remanded it. Most of my cases actually have been remanded, asking the hearing examiner to correct the errors and then, apply all the factors once the errors are corrected and decide what level to classify my client. So there's factor 9, but also the hearing examiner committed error by failing to give my client risk mitigating weight to factor 32, which is sex offender treatment. As you know, my client did submit a letter indicating that he was involved in sex offender treatment from 1990 to 1994, and he did finish sex offender treatment. The hearing—
But wasn't it your client's responsibility to produce something that shows he completed it?
That is correct. And my client's attorney did attempt by writing to New York multiple letters requesting these records, but it appears that since it's been such a long time, about 30 years, and also the facility is no longer in existence, that those may have been the reasons why my client was unable to obtain those records. And I know the regulatory factor does say that it is the offender's responsibility to obtain those records, but under this specific circumstance, and also the hearing examiner does have discretion to apply. It doesn't say the hearing examiner cannot apply unless there is more evidence other than the offender indicating that he was involved in sex offender treatment. So my argument is that under these specific facts of the case, it was unfair for the hearing examiner not to give my client credit.
Even if that's true, counsel, though, considering how little even your client remembers, just that he never missed a meeting and he completed it, nothing about how well he did, what he learned, how much weight could it really be given?
Well, it could have been given minimal weight. I agree that the hearing examiner should not give it full risk mitigating weight because, as you said, it was such a long time ago and there's very little information that even my client remembers. But my client does remember finishing. Again, it was almost 30 years ago, but he does remember finishing sex offender treatment. And the hearing examiner should have given him the benefit of the doubt in that regard.
The letter in the file contains an assertion from your client's counsel that I think it was the Arthur Kill facility in New York had closed.
Yes. Yes, it had closed.
Was that disputed at the hearing? Is there any dispute that the facility was closed and that the records may have been destroyed?
It was not disputed. No, it was not disputed.
Was there ever a response from New York that said we've destroyed the records, or was the only response the one that I saw that said we've been unable to locate them?
That's the only response. The hearing counsel and my client assumed that they were destroyed under these circumstances since the facility no longer exists, and also, almost 30 years had passed at that point. Again, my assertion is that the hearing examiner should have given that factor at least minimal weight, because my client did indicate that he did attend and complete it. As you'll see, my argument is my client should have been classified as a level 1 sex offender. His governing offense, again, was in 1990, close to 30 years ago. It was one victim, and it was somebody he knew, so it wasn't a stranger. He used no weapons, caused no injury, and used no violence towards the victim. He has accepted full responsibility for his actions and feels remorseful for what he's done. And as I indicated, he was involved in sex offender treatment. He's been offense-free in the community since his last incarceration, which was 2007. He's been drug and alcohol-free since 1990. He was 23 years old when he committed his governing offense, and he's now in his 50s. He does have a stable and supportive home environment. He lives with his fiancée in Fitchburg, and her family is fully accepting and supportive of him. He did submit letters of support from his fiancée, his brother, and multiple friends. And he does work. He's actually had a pretty great work history for multiple decades now. And he works as a truck driver right now, which is a full-time job. And he's been there for at least 3 or 4 years now, and has been doing a great job with that. And so for the reasons I've discussed, I'm requesting that this court either remand the case for another classification hearing or lower the classification level from a level 2 to a level 1. And if there's no further questions, I'll rest on my brief.
Okay, thank you very much.
Thank you.
Attorney Doyle.
Good morning. May it please the court, Thomas Doyle for the board.
Let's just wait a minute. The timer's not correct. Okay, sorry.
I would note that the board does recognize the age of the index sex offense. I mean, as we sit here, it's 30 years. At the time of the hearing, I believe it was 24, something like strike that, 16 years. But having said that, the facts are the facts, and they allow the examiner to apply the factors in this case, including a high-risk factor. The issue of
the authority, Attorney Doyle, to reduce this to a level 1?
You know, Your Honor, I was thinking about that when you asked the question, and I know in the Superior Court under 30A, it does give the Superior Court justice the authority to do basically as he seems fit or as justice provides. And I have seen, I've been with the board 14 years, I have seen probably a dozen instances where a Superior Court judge has reduced the level based upon the record in front of him. So, but I would ask as representative of the board, if there were issues with this, to be remanded for another full hearing and go from there. As to my sister's arguments for the hearing examiner finding that he raped his girlfriend, as I said in my memo, it's clear that he cut and pasted or just verbatim took the narrative from the police report, but he did get it right and as a matter of law in finding that the attempted rape in the state of New York was a like violation of the Massachusetts sex offense of an attempted rape. So I don't think there's any error there. If there was any error, it's harmless because he ultimately got it right and he determined that it was an attempted rape based on the Massachusetts offense as compared to the New York offense. As far as the 2006 case, this is a situation where that 2006 case is very important. As my sister said, it does invoke a number of factors, including a high-risk factor if it is found to be reliable. That is the position of the board. We have a situation where a 16-year-old female made a sexual assault allegation. This court knows that you can consider hearsay as long as there's an indicia of reliability in that hearsay. And this court has laid out the preponderance, or strike that, the criteria for the indicia of reliability. Some of that is, as you know, common indicia of reliability include a detailed account, the consistency of the hearsay incident with other known behavior, admissions by the offender, and independent corroboration. I think three of those four have been met. You have a situation here where she gave a detailed account of the allegation. There was penile penetration. Plus you have the fact that there was a rape kit done. Now, notwithstanding the fact that apparently there was no sexual assault charge, you have a situation where after that allegation was made, the petitioner was charged with menacing. The victim alleges that he threatened her with a gun and told her to change her story. And what do you have as a result of that? He was convicted by plea of menacing, second with a gun. I think that connection, which is undeniable, is, I mean, why else would he menace her with a gun if not for the alleged allegations of rape? I think that in and of itself leads an indicia reliability to those allegations that he did sexually assault that 16-year-old female. That's not a conviction, but it does include it does come under the definition of sexual misconduct, which allows the application of factor 2. It also allows the examiner to apply the highest level of, yes.
Counsel, Justice Ditkoff trying to ask you a question.
Oh, I'm sorry.
Counselor, he might menace someone because they're falsely accusing him of rape? Why does the mere menacing or even the mere fact of a rape kit corroborate the penetration allegation?
I think you need to, if you look at somebody who's making a sexual assault allegation, a 16-year-old girl, she's going to go through all this trouble to make this allegation, describe exactly what she said happened, and then actually physically take herself to the hospital to have a very invasive procedure done in the form of a rape kit. That in and of itself might be something that could go either way. I would admit that. But then you have within, I think it was 60 days, he menaced her with a weapon, which he did plead guilty to. And I think, I understand your question about, well, why wouldn't he go after saying I didn't do this? If he didn't do it, I don't see the logic of menacing or threatening her with a gun. So I think the opposite would be true. And I don't think there's any error in the examiner going in that direction.
What are the details you say are in this account?
I'm sorry, Judge?
You said this is a detailed account. Could you give me the details?
Well, I just, what she said, I understand these 30 and 24-year-old police records are very sparse, but she alleges that she was visiting her friend, which was the daughter of the petitioner plaintiff. He came after her, sexually assaulted her, penetrated her, and she alleged a rape. And then as that case was being investigated, I assume, he threatened her with the gun within several months. I think it was 30 to 60 days. And he pled out to the menacing. And from what I can see from the record, there was actually he didn't do it. Nothing happened with the allegation of the sexual misconduct. I don't even know if he was charged. It doesn't look like he was charged. I really couldn't find anything, but the allegation was made. But because he had already been convicted of a sex offense, the examiner was able to not only apply factor 2, but the highest level of aggravation on factor 2 because he had been convicted prior of another sexual offense. So I would argue that there is an additional reliability there to imply that there's reliable evidence to the hearing examiner to use that sexual misconduct as reliable evidence to apply factor 2. Therefore, that does impact the high-risk factor, and it does give the fact that now you have 2 victims of sexual assault, implying another factor.
You think without the 2006 rape that you have enough for an examiner to be able to find level 2?
I think it would be a much tougher call if there wasn't enough, if you weren't able to rely on the 2006 incident. Because that not only applies factor 2 is in the highest level of factor 2, but I think it ups the dangerousness too. You have a situation where now you have a gun involved. You have a gun involved in basically threatening a witness or threatening a victim. So, right, if you didn't have, I probably would concede, if you didn't have the additional reliability in the 2006 incident, it would probably be much tougher for a level 2 in this case. Because as I said at the beginning, it is a very old case. You could actually make an argument that he escalated his behavior, I would argue too, because he allegedly attempted to rape the girlfriend in 1990, got convicted of that. And in this case, the allegation is that he did complete the rape and then he used a gun to furtherance the criminal activity associated with it.
Plus a younger victim and a less connected, a victim that he knew less well.
Right. I mean, they were both extrafamilial victims. I think you could make the argument that, at least under the board's regulations, the victim was a child. I mean, even though she was 16, I think the board's regulations now are anyone under 18 is a child. But that 2006 incident is key in this situation. And I believe the examiner did a thorough analysis based on the information he had. As my sister said, he did make multiple requests for more information, but most likely because they were so old, I assume the New York authorities didn't have anything to give us.
Well, doesn't that mean that Doe satisfied his obligations under the statute to produce the evidence? At that point, wouldn't the burden shift elsewhere?
Are you speaking about the treatment, the sex offender treatment?
Right.
Once
he's gone to all those lengths and he's there's a representation in the record that nobody disputes that the facility is closed and the records are probably destroyed. He he can't be faulted for not producing non-existent records, can he?
If they don't exist, they don't exist. I mean, the factor is clear. I don't believe it's any kind of burden shifting. I mean, if you think about it, the person who's best in the position to get sex offender treatment records is the person involved in the sex offender treatment.
But he's not the keeper of the records. The facility is.
That's true. But I think if you left the burden on the board would, I would say 100% of the time, run into confidentiality issues where, especially out of state, somebody would like, I can't give you this stuff without a waiver from the.
He signs a release, but that's not the issue here. What I'm talking about is a situation in which records due to age or the closure of a facility are either lost or destroyed, or at least, unable to be found. And it's one thing to decide whether or not to credit his testimony on the point or what weight to give his testimony on the point. It's another to say, I won't consider this factor at all because he didn't produce the records.
Right. Well, the records are the key, obviously, and the factor goes in depth on what they look at, whether it's completion of treatment, currently in treatment, past participation in treatment, and denial.
But
you can't do any analysis whatsoever if there's no paper trail. And like I said, and it's obvious that he's in a better position to get it. In this case, he couldn't get it for whatever reason. They were destroyed. They lost them. I'm not quite sure how he can get credit for any of that if the examiner can't analyze any of the paperwork.
Well, my only concern with this is that the examiner, if I recall the decision correctly, said he failed in his burden and therefore I don't consider it at all, rather than he satisfied his burden in his effort to locate these records, which are now non-existent. But I give his testimony XYZ weight because of the unavailability of the records. They're two different analyses, that's all. And I wouldn't be making an issue of it were it not for the fact that we have this issue before us on whether or not the findings are adequate on internet dissemination.
Right, which was my last.
The hearing examiner said that it was essentially that it was a close call.
Right. Well, if you flip your argument, Your Honor, and you say, well, he did his best, he tried to get them. I'm not quite sure how much weight that the examiner should give something that doesn't exist. And he says, well, I did treatment and I know I did this. I don't believe he testified under oath. I think he wrote a couple of letters into the record, which, the hearing examiner is free to credit some, none, or all of it. Apparently, in this case, he didn't credit any of it because he didn't have the documentation.
That's my point. He didn't get to crediting because he
Right.
said you didn't meet your burden.
Right.
And we have to figure out, among the issues that you're going to be arguing to us in a moment, is the internet dissemination issue.
Right.
So it's all of a piece.
Yes, Your Honor. And as to the internet findings, the express finding, obviously this case came out 2 years before the SJC decided in 496-501 that there needs to be a more thorough investigation and analysis into the examiner putting somebody on the internet. Basically, the standard is whether there's substantial evidence to support the finding, and is that shown by the correct application of the factors. I would argue that that is the case here. After establishing the level of dangerous posed by the offender and consider the severity and extent of the harm, I would argue there's multiple prongs for that. Obviously, the use of a weapon would be one of those, and obviously the fact that he had multiple victims of different ages. I would argue that to support the facts show that you do not need to remand. And finally, the court considered whether internet dissemination of the sex offender information would serve a public safety interest. I would argue that it would, based on the facts in this case, because you have a victim that was 16 years old, and the court was concerned it would enable residents with children to determine whether the plaintiff lives in their neighborhood. The last thing I would say, and the SJC pointed this out strongly, is that there is a difference between contact and non-contact offenses. And they talk about how contact offenders are generally more dangerous than non-contact offenders. And that's 496-501 at 659. Here you have two contact offenses. One he was convicted of, and one where that was, I would argue, supported by substantial evidence in that he allegedly raped a 16-year-old girl. So I would ask the court not to exercise its discretion and remand it based on that on the internet dissemination finding. Other than that, I would rest on my memorandum.
All right. No further questions? Then thank you very much. And that concludes our argument. Well done, both counsel.
Streaming again. All right, we are live.
Thank you very much. This is our 5th case, number 19P0456, Doe number 35547 versus Sex Offender Registry Board. This is an impounded case, pseudonyms only, please. Counsel, you may proceed. Please identify yourself for the record.
Thank you, Your Honor. Eric Tennant on behalf of John Doe in this case. This case, I think, is relatively straightforward, relatively simple. It is asked this court to apply 2 recent SJC decisions, both of which admittedly came out after the hearing in this case and even after the Superior Court appeal in this case. But both speak directly to errors I think the hearing examiner made. So the first issue has to do with what the hearing examiner did with the expert testimony. So there was expert testimony about a variety of issues. And as hopefully the court is aware, in the recent case of Doe 23656, the SJC affirmed that an expert may testify only as to one prong and what they normally do about risk. And that's what happened here. And their opinion can't be rejected simply because they are only testifying as to one prong, even though SORB through the hearing examiner has the obligation of looking at multiple prongs, including danger. And so the hearing examiner here very clearly, I believe, rejected the expert for doing just that. That is, for not looking at everything that he must look at and in violation of Doe 23656. And so, for example, and it's not much, but the hearing examiner has about a paragraph that he explains why he's rejecting the expert testimony. Testimony which, among other things, the expert talked about the John Doe being an extremely low risk, relied on 2 actuarials and explained how they impacted this case and why they led the expert to that conclusion. And then again, the expert, I think, was clear that he was only assessing risk to reoffend. So the hearing examiner rejected him, saying even though he uses these actuarials, he doesn't consider all of the comprehensive statutory factors set forth in the regulations. That is another way of saying he didn't consider everything I have to consider, which is risk and danger. And that an opinion cannot be rejected for that reason. The hearing examiner then also gave a very brief, or a couple of sentences that he also felt that the doctor and him parted ways on, as I identify them, 2 factors. But again, this is problematic because those factors generally speak to danger and not risk. So the hearing examiner said, for example, he specified the amount of force and the level of physical contact, saying that he parted from the doctor in that sense. Level of physical contact, I'll start with that one, which is factor 19, is a factor that speaks only to danger. It does not speak to risk to reoffend. That is in the regulations. And so the doctor would never rely on that factor because, as he said, this factor has nothing to do with risk. My opinion is about risk. So the hearing examiner saying that he and the doctor differed on that factor doesn't help his rejection of the testimony because he's singling out a factor that the doctor did not consider and does not have to consider.
What about factor 8?
So the other one, amount of force, factor 8. This one's a little different because there's multiple factors. This is one of them that considers that speak to both risk and danger. And so they say this factor might impact risk to reoffend and danger to the community. And this is one of those factors. The problem is the hearing examiner didn't say what he was using that factor for, and therefore didn't explain why he was rejecting the doctor's non-reliance essentially on that factor.
Well, Dr. Bard seems to think that excessive violence or pleasure in violence would increase dangerousness. I mean, I get that from his report. Is that not right? Otherwise, why did you mention there was no excessive violence or violence used for the individual's sexual arousement, no cutting, no binding, nothing that would indicate it was violence that was sexually arousing? If that wasn't relevant to the what he was talking about, why was that in there?
Oh, I see. I understand your question. Because he's talking about what things might impact his risk assessment. It's not a danger assessment. So he's saying there are situations where the person's behavior might impact risk. And in that sentence, as I understand it, I think he was getting at the fact that if this had been conduct that indicated some sort of paraphilia, some sort of mental disorder, that might impact risk. But Dr. Bard's opinion is never about danger. He doesn't do danger assessments. Doctors don't do danger assessments.
But where sort of it's in the factor, and the doctor seems to agree that excessive violence or pleasure in violence could increase risk. If the examiner disagrees with Dr. Bard about that statement, there's no excessive violence, isn't that a basis for discounting his opinion to some extent?
I think it could be if the hearing examiner explained, I'm looking at this factor for risk purposes. And I disagree with Dr. Bard's application of this factor. He says it's not applicable. I say it is. So if he had been clear in that sense, then I would have a different argument. But he doesn't do that. And I think in the context of how he's rejecting the opinion, the other things, the other factor, and the fact that Dr. Bard is not looking at all the factors, all the danger factors, I don't think you can make that presumption.
What was in front of the examiner as far as the facts of the rape?
You mean literally as in the police reports, or what are the facts?
Police reports, trial transcripts. I mean, what did he have?
My recollection is there were police reports. I don't think there was trial transcripts because it was a plea.
It was a trial.
I'm looking at the what he lists, and I see police reports, arrest reports, reports of the detective, the criminal dockets, some corrections reports, and everything else is not about that case. Probation reports, things like that. So I don't believe there were any transcripts. I believe it was all based on police reports, and then whatever Doe himself reported to Dr. Bard, that Dr. Bard then put in his report about what happened. So coming back briefly to kind of conclude this part of the argument, the doctor, the hearing examiner, that's the only reasons he gives for rejecting Dr. Bard's testimony. Again, testimony or opinion about risk. But for that one factor that's a little ambiguous, that had he been clearer, maybe would have allowed him to disregard it. The other things, the other reasons clearly are not reasons that allow a hearing examiner to reject expert evidence under 23656. So that alone, I think, warrants remand for further consideration within the parameters of Doe 23656. If there's no other questions about that issue, I'll move on to the second issue.
This may be solely an issue of characterization, but did he reject the expert opinion, or did he say, I give it only so much weight because it goes to this one issue and I have to consider so many others?
You're right. He didn't reject it outright, but he didn't. But he didn't put that qualifier, however, that it only goes to one factor and not the other. And so I don't think you can give him the benefit of the doubt for him rejecting it in part on the risk part of it, for example, or that part of it, because that's not why he says he's not looking at it.
And well, that's my question. Does he say I'm not going to look at it, or does he say I looked at it, but at the end of the day, I'm not going there because this is a very nice expert, but I have to consider all these other things too.
The direct quote is, I give Dr. Bard's opinion only some weight. That's the most he says about what he's doing with it.
Right.
But if he's rejecting the risk assessment part of it based on the fact that Dr. Bard doesn't look at the danger part of it, then it's not clear that he can limit the weight he gives it on those grounds. That's the problem. He's not specific enough to maybe parse out, or maybe he could have parsed out the way Your Honor is asking, and saying, well, on the risk part, I give it full weight, but because it doesn't consider danger, I do my own analysis of that, something along those lines. He doesn't do that. He doesn't clarify that. And one of the other things we learned from Doe 23656 is that if a hearing examiner is going to reject expert testimony, they at least have to be clear about why it is, so that a reviewing court can see that it's a valid reason. And what he says that is clear is not a valid reason, and everything else I think is at best ambiguous. Again, to Justice Ditkoff's opinion about the force, and to your question about force, and to your question, Justice Sullivan, about what kind of weight he gives it. Moving briefly and quickly to the second issue, an issue that I know this court's familiar with. I just heard the tail end of the prior argument, and so the court obviously is familiar with what needs to be applied in the situation. This decision did come out, the hearing examiner's decision did come out before the Doe 496501 case, and actually I think the Superior Court decision also. But in this case, the hearing examiner nevertheless made no specific findings about internet dissemination. And so this court has to determine whether it can, based on the record itself, uphold it or remand it because it needs further clarification. I think at the very least a remand is necessary when, number one, you have the errors that I just pointed out. So it's not clear, had he accepted Dr. Bard's opinion, what that would have done to the analysis here. And second of all, the factors that he does cite that I don't dispute, that there's the factors that he finds present that I don't dispute, nevertheless don't in and of themselves support the idea of internet dissemination. So you have one sexual offense from 2001 or the late 90s to the early 2000s. It's against a known adult female. The known adult part, I think, is the most important part of that, because first of all, known to him, internet dissemination or dissemination of any kind is most important and powerful, if you will, when someone's strangers happen to be people he does not know. Someone's victims have to be people he does not know. They happen to be strangers. That's when the community is most, in theory, can make most use of that information. And you don't have that here.
So that's kind of what my instinct is. But Dr. Bard, on page 70, the transcript seems to say that's not supported by any scientific approach. He says you could argue that since the offender knew his victim, then one could argue if he's going to offend, it would probably be against someone he already knows. I try to avoid that. I look at that goes away from any scientific approach. Helps.
So Dr. Bard was, whatever he says about it, I think what he is actually saying is that there's no support that dissemination is related to offending or that this is necessary based on someone's offense. But he doesn't say that therefore means dissemination in this case is warranted. Again, nor was he called to give that opinion. The hearing examiner is is the entity that is tasked with justifying whether, given what they know about this and whether what they believe might happen if the person reoffends, right? That's the danger part of it. How severe will it be? And then dissemination, who should we tell about it? These facts do not support that kind of dissemination would make a difference here. Again, the victim was known and it's an adult. Things that are different than the only case I've seen being the SJC back to the 23656 case where they didn't remand it, but based on what the record they had said, we have enough here to say that dissemination was correct. These are two different, a single offense, known, adult are all distinctions from other cases in which the record was sufficient to do it. So in that respect, this record as it stands, I do not believe is enough to warrant dissemination. And again, at the very least, I think remand, given the errors, is necessary. My time's running down, so if there's no further questions, I would just rest.
All right. Thank you. We'll wait a moment. There we go. Attorney Chennai.
Good morning, David Chennai for the board. The board's position is that, for an expert to be considered by a hearing examiner, the hearing examiner is not obligated to accept all of the expert's evidence. And the hearing examiner is allowed to reject portions of evidence or portions of an expert's evidence if there's a basis in the record to do so. Here, the hearing examiner agreed with much of what Dr. Bard said. Their only disagreement was the actual final opinion as to risk. The hearing examiner found it to be moderate, and Dr. Bard found it to be low, obviously. The hearing examiner specifically said, I agree that his record while incarcerated, his age.
Oh. We can't hear.
This happened once before with Attorney Chennai last week.
It happened last week.
And our solution was have him call in, and then
Right.
it looks like he.
I think
and
he must remember Brittany from last week.
I can also chat him as well. Would you like me to keep live stream going while Mr. Chennai gets back?
This might take a while. What if we go off for a moment and give you the space to fix this problem off screen?
And find this violence to be the type that you would factor into it. So what he basically did is he took positives. What was interesting on cross-examination, he said those positives didn't really change the results of the actuarial testing. So he was really basing his analysis on that actuarial testing. And again, the hearing examiner had disputes with the factual findings, such as his claim that the individual was sober was based on self-reporting and he had no evidence. The fact that he gave him credit for a sex offender treatment, but he had no evidence of what that treatment consisted of. In fact, said that at the time he'd been to as far as the meeting with the treatment provider at the time of his testimony, but he gave him credit for those as well. So there were factual problems with analysis, and again, the hearing examiner believed there was an over-reliance on the actuarial thing. Now, what's interesting about this case, and I do this in his testimony, Dr. Bard specifically, he probably would sexual.
Counsel?
And when he gets angry, he.
Counsel, can you move that telephone?
Then he will most likely commit type of crime, not sex crime, because of his anti-orientation. The factors specifically say, factor 133 says in an introduction, research, excuse me?
Just wanted you to move your phone a little closer because you were cutting in and out.
I can't hear you.
Oh, no.
I can't hear. Oh. I'll do this, that way it'll be a little closer, I think. It's too close?
Okay, can you hear us?
Can you hear me?
Yes.
Yes.
I can't
hear us.
You. I can't hear you.
All right, let's go offline again.
Confirm when we are live streaming again. All right, we are live streaming.
Back to the point I was making is that Dr. Bard makes it clear this individual, who he is an antisocial person who will commit crimes in the future. And the regulations specifically say that one of the key indicators for all sex offenders in sexual recidivism is an antisocial orientation. He also says that this individual's risk will go up should he have any substance abuse resumption. And again, he based his understanding of this individual's sobriety solely on his self-reporting. For these reasons, especially after the 2011 assault and battery, domestic assault and battery, that it's clear that internet dissemination is warranted. You have an individual who has a history of antisocial behavior, which Dr. Bard said is going to cause him to continue in a criminal lifestyle. And he also said that should he resume his consumption of alcohol, he will be a risk. Now, this is an individual starting in 2004 when he was convicted, or 2002 when he was convicted, has been in prison pretty much from 2002 to 2014 for all but about 2 years. And in that 2 years, he committed his domestic assault and battery. So there's indicators that this individual's risk is elevated. The hearing examiner found it to be at a level 2 because, again, the hearing examiner accepted Dr. Bard's findings that there are positives in this case for this individual. But based on that, the hearing examiner properly disregarded the final risk opinion by Dr. Bard, and more importantly, there is sufficient evidence that this individual's current danger is such that internet dissemination is required at the time when he was classified. So based on that, unless there's any questions, the board would rest on its brief.
If you know, why in a case like this would the board rely just on police reports instead of the trial transcripts? From
Right. The requests are gone out to district attorney's office, police departments, and to the courts, and we're pretty much dependent on what they send us. We can only ask for all the records that they have. Very seldomly do we actually ever get transcripts of trials. And with 2001, I'm not even sure if they were available for a 2001 or 2002 event. And that's one of the problems we have with some of the older cases. It's even hard sometimes to get police reports because police departments don't keep those records. And a lot of the records were before they put things on digitally. So a lot of records were destroyed over the years. And I've had cases where we've asked for records and ended up with just a statement saying that the record doesn't exist anymore. So we're really dependent as a board on what these agencies send us.
I mean, I don't know if you contact the appeals court, but I can't believe they would have refused to give you transcripts.
I'm not saying anybody refused. We just send out the request for all information, and they send us what they send us. I'm not sure that we've generally gone out and sought the transcripts of cases. We just send a request for all the information that they have, and we get what they give us. If there's no other questions.
Are there any further questions? All right, that concludes our argument in this case.
Thank you.
We are live streaming. Okay, we are live.
This is our sixth and final case of the day, 19P1460, KRIS England versus Big Y Foods, Inc. Attorney Fletcher.
Thank you, Your Honor. May it please the court. My name is Steve Fletcher. I am the attorney for the plaintiff appellant in this case, KRIS England. KRIS England was an employee of the defendant appellee, Big Y Foods, from 1996 until January 15, 2015, when she was fired. And this case was brought in January of 2017 by our filing a complaint. Big Y Foods, I should say, is a supermarket chain I believe it has over 100 stores in Massachusetts and Connecticut. In her complaint, Ms. England alleged that Big Y Foods has an employee handbook, which it does, and that it has a progressive discipline policy in that handbook.
Mr. Fletcher, let me interrupt you if I could, because we have read the pleadings and the briefs. Does the entirety of your case rise and fall on the question of whether or not the handbook is tantamount to an implied contract?
It does, Your Honor.
Okay.
Well, excuse me.
Sure.
I think I misunderstood the question. Big Y is arguing that it rests on whether the entire handbook is a contract. That is not our contention. Our contention, it's only the progressive discipline policy portion of the handbook that constitutes an implied contract.
But if we disagree with you that this is an implied contract, do your claims fail?
They would.
Okay. So can you take me through your argument under Ferguson as to how this is an implied contract?
Well, I think this case lines up on all fours with Ferguson, Your Honor. This is Big Y had a very detailed progressive discipline policy set out on pages 34 to 36 of the handbook, sets up 3 levels of violations, as to which there are 3 levels of counseling. Group 1 violations are the least serious. Group 2 violations are more serious. Actually, there's only one Group 2 violation. It's referred to as a decision-making leave. And then the 3rd level of counseling is actually termination.
So you want us to excise the progressive discipline component of the employee handbook and say that that portion of the book is an implied contract?
That is correct. And if you just confine yourself,
well, what is the authority to exercise just that portion? Don't we have to look at it in its totality?
You look at the progressive discipline policy in its totality.
No, don't we
look at the entire handbook?
Counsel, don't we have to look at the entire handbook? We can't just pick and choose which sections of it to look at. We have to look at it in its entirety.
To see if there's anything in there that would cause an employee under the standard that has to be applied, whether that handbook in its entirety would induce a reasonable belief in a Big Y employee that the employer, Big Y in this case, meant to abide by the terms of that progressive discipline policy.
So then if we do that, page 1 in capital letters at record 71, the contents of the handbook do not constitute the terms of a contract of employment. Under your analysis, you don't want us to look at that, but don't we have to?
No, I think you look at that as the reasonable employee would look at that and read those general terms. And I think here's where the rabbit hole enters in that Big Y's argument is that, well, she was just an employee at will. So therefore, the progressive discipline policy can't apply. But it's clear, the law is clear in Massachusetts that an employee handbook may become an implied contract, even in the context of an at-will employment. The two are not mutually exclusive. So the fact that there is wording on page 1 of the employee contract, 33 pages before the very particularized wording of the progressive discipline policy, the fact that that page says, well, you're an at-will employee and there's no guaranteed term of employment, nobody's arguing that. It's not inconsistent with the progressive discipline policy. And you have to ask yourself 2 questions, Your Honor. If the Big Y's position is that they can apply the policy as they see fit, I'm not talking about particular instances of conduct, I'm talking about the policy in and of itself, then you have to wonder why they go to that entire trouble of setting up the policy at all. I mean, the reasonable employee would, The reasonable employee is going to read that discipline policy, which in and of itself doesn't have any of the discretionary language regarding the policy. It doesn't say it's for guidance only, which is one of the criteria. It's very particular, with very particular provisions, including, and what's crucial in this case, that no counseling record remains active after 12 months. You'll note Big Y doesn't even deal with that. They don't even mention that, but that's a very particular provision in the disciplinary policy and would lead the reasonable employee to believe that unless, and there's always an escape hatch for egregious conduct, but that's not even alleged in this case. Big Y says it followed the policy. That unless a particular disciplinary act occurs within 12 months, it's not to be considered for purposes of discipline.
Where does
Big Y
it,
denies that, but they never explain what those words are supposed to mean.
where does it say that? Where does it say anything that happens more than 12 months earlier can't be considered for discipline?
Where it says it, it's on, I believe it's on page 181 of the appendix, Your Honor, where it says counseling records are no longer active after 12 months.
It says, infractions of company policies do not progress independently of each other. Rather, the progression is a combination of all infractions, and all counseling records remain active for 12 months. It never says that they can't be considered. In fact, it kind of implies that since it's a progression, that they can be considered.
What does remain active for 12 months mean within the context of a progressive disciplinary policy? What else can it mean, Your Honor?
It could mean, well, I shouldn't answer questions, but for example, if someone gets probation, that remains active for the term of the probation, but it's not like that crime doesn't get considered if someone commits a new crime after the term of probation. I mean, why should we read it this way instead of the way you're reading it?
Because I think by the way I'm reading, it's a natural import of the language. It's also reinforced. If you look under the level 2 counseling guidelines, that spreadsheet that follows the policy, it talks about an enlargement of punishment if it occurs within 12 months of that level 2 counseling of a decision-making lead. So it's repeated twice, this 12-month period. If the reading were that Big Y can do whatever they want, they didn't have to go into this detailed description of violations and level of counseling. And there's all sorts of language in that policy on how it's to protect the employees, to be brought to their attention. They're to sign for it, to make sure that they're aware of the record, and it is a record. Counseling records are what are used to determine appropriate discipline.
What do we make of the fact that at the very outset of the manual, it says, the employee should be aware that these policies and programs may be amended at any time in the company's sole discretion with or without notice. And this frankly is fairly unusual. I don't know how often I've seen this. And that depending on the particular circumstances of a given situation, the company's actions may vary from the written policy. How do we factor that in? Let's say we read the 1-year period as you're suggesting. It doesn't explicitly say that it'll be removed from the file, but let's just say we read it that way. Why doesn't this language permit them to override that?
Well, I think this is where Ferguson comes in with its emphasis on the disclaimer. And that's what this is a disclaimer. We've got page 1, we've got one paragraph on page 1 with this general language, which is being proffered as a disclaimer of responsibility of Big Y to perform anything in the handbook, including, if you apply this logic, Your Honor, the benefit programs that are described in the handbook.
Yeah.
So here you have a 401k. I think it would come as a surprise to the reasonable employee that the handbook is being interpreted in such a way that their benefits could be yanked out from under them because
Well,
Big Y has the total discretion. Well, that's the logical import that you're saying the reasonable employee reading this handbook would conclude. He shouldn't even go beyond, or he or she shouldn't even go beyond page 1. Why should I read anything in this handbook? Because there's nothing here to rely on. That's the argument.
Not a collective bargaining agreement, it's a handbook.
That's correct.
With
And,
a very substantial disclaimer.
well, substantial perhaps to attorneys who are attuned to how these cases, parse language here. But I think the ordinary employee reading that, in fact, if you apply ordinary contract rules to it, this is general language, and then you have a whole bunch of specific sections that follow it. Under ordinary contract construction, the specific would control the general. I mean, I think the fair way of reading that page 1 is, well, it's a general warning that Big Y retains discretion. We can change these manuals, but O'Brien and Ferguson said, yeah, that could also be read by an employee as meaning, yeah, they change them from time to time. They don't need the employee's permission to do them, but they could be changing them to improve conditions for employees. So to me, that's not a fair warning to employees that that this entire disciplinary procedure, mechanism, and protocol that's set up is simply something that the employer can choose at its whim to utilize. And I think the Woolley decision that the courts have followed, that New Jersey Woolley case, and set out the policy quite plainly. It's entirely with the employer to draft these handbooks, Your Honor. They can control the language. Ferguson said, if you don't want it to be construed as a contract, very simply say that. And they gave a bright line test, which if you're an employer attorney, you wonder why this isn't in the very same language that the court has laid out over 19 years ago.
Counsel,
why don't they say that?
Counsel, you're short on time, and I wanted to be able to ask you whether or not there was a grievance procedure in this contract. There is this peer review process. Is that a grievance procedure? And do you agree that she failed to invoke it?
They call it a grievance procedure. It's in a separate section. It's not even referred to in the progressive disciplinary policy that, oh, by the way, you can file an appeal. It's a very informal process. It's not something like a collective bargaining agreement would provide, such as arbitration. It's made, you go before a committee of 3 peer employees and 2 management employees, and it's just sort of a meeting, and then they decide. What's key here is that it's not available if you're guilty of misconduct. They admit, her own manager admitted in a deposition that the conduct that they terminated her for was misconduct. So right away, whatever the peer review process is, she was not eligible to utilize that process. Another key feature which distinguishes this quote unquote grievance process from, I think, what O'Brien and the other cases have in mind is that it says it's final. So the employee who is quote unquote eligible to utilize this peer review process gets to a dead end. There's nothing there about, well, then you can go on to court, which is the ordinary model with collective bargaining agreements, that administrative remedy through the employer you have to exhaust first. Well, you exhaust first, then you can go to court. I mean, the arbitration rules limit the scope of review, but nevertheless, you get to go to court.
Well,
Big Y would be arguing you can't do that here.
Counsel, your time has expired. There may be one more question.
Justice Sullivan, may I ask one question?
Yes.
Why are the 6 note to files not admissible? Why do you say they're not a business record under 233?
Well, that statute is an exception to hearsay. So first off, they also have to be authenticated. They're never authenticated in this case. so far as this record's concerned, they're random notes. And so that's the first. The second thing is that there are notes not in the ordinary course of business. I mean, they're employee complaints, they come in, there's that indicia of reliability that characterizes business records, like bank records or other stuff kept in the ordinary course of business. That's lacking here. You don't see that with, you know, random employee remarks.
Thank you.
Thank you.
Thank you.
Okay. Attorney Pickett?
Good afternoon, Your Honors. May it please the court. My name is Andrew Pickett and I represent the appellee Big Y Foods.
Could you start where I just left off and tell me why the 6 notes to file fall within 23378?
Because, Your Honor, as authenticated by the affidavit of Jamie Swenson that was submitted as part of the summary judgment record, these were records created in the ordinary course by managers documenting conversations with Ms. England about performance issues. And they were pretty consistent starting in 2002, that employees she was managing would complain that she was insubordinate, that she didn't respect them, that she dressed them down in front of other employees. These were made in the ordinary course. In fact, the Massachusetts Personnel Record Statute says that if you're having conversations with an employee, verbal counseling, whatever, and you make notes, they have to be included in the employee's personnel record. And that's what Big Y did. And Ms. Swenson's affidavit authenticates that these were in the employee file, made in the ordinary course of business at or about the time of the events in question. And that's exactly what the business records exception is about.
Attorney Pickett, in your experience, when these notes come in at trial, and they always do they come in for their hearsay or their non-hearsay purpose?
Your Honor, they come in for the purpose of showing what the manager believed and what the manager counseled the employee as to the underlying statements, whether they were made or not. I think there's instructions that could be deemed to be hearsay, but that's what the employer believed at the time and told the employee whether reasonable or not.
That's my understanding, that they definitely come in for their non-hearsay purpose. It's an interesting argument that you're making here, that they come in as business records for their hearsay purpose, but we can move on.
Okay, very good. So I think, as Your Honor's questions illustrate, from our perspective, this is a very straightforward case. We believe that the trial court correctly ruled that Big Y's employee handbook could not possibly be an implied contract, given the disclaimers that were in the handbook, and in particular, the disclaimer that appears on page 1. And this is consistent with this court's express guidance in Ferguson and prior guidance by the Supreme Judicial Court in O'Brien and Jackson. And in this case, Big Y's handbook prominently states in all capital letters on page 1, the language that I believe Justice Blake read at the beginning. But I want to point the court to that entire statement because I think it further illustrates how this could not possibly be an implied contract. And I fully agree that there is no precedent saying, well, the handbook itself may not be an implied contract, but just the progressive discipline section is, and I'll address that in a minute. But if you look at Record Appendix page 180, this is the first page of the handbook. And let me just start with the fact that the court in Ferguson, Your Honors, instructed that if the employer, for whatever reason, does not want the manual to be capable of being construed by the court as a binding contract, there are simple ways to attain that goal. And then you gave an express instruction, Your Honors. You said all that need be done is the inclusion in a very prominent position of an appropriate statement that there is no promise of any kind by the employer contained in the manual, that regardless of what the manual says or provides, the employer promises nothing. Big Y, in essence, exactly mirrored that language and instruction. And the paragraph that has the capital letters says the contents of this employee handbook summarize present Big Y programs and policies. The employee should be aware these policies may be amended at any time in the company's sole discretion. As you pointed out, Justice Sullivan, it's very powerful language that was not present in O'Brien or Jackson or in Ferguson. Then there are the capital letters that it does not constitute the terms of a contract and employment. And then Big Y even uses the word nothing, After those capital letters, it says nothing contained in this handbook should be construed as a guarantee of continued employment or treatment in any particular manner in any given situation. I think that really says, excuse me, Your Honors. I think that really says all that needs to be said as far as the Ferguson factors are concerned, as informed by Jackson and O'Brien.
Is that language in any way undercut by the giant banner on top that says this handbook was written for you, exclamation point?
I don't believe it is.
It appears to be a bit of a mixed message.
Well, it's a mixed message if, as Your Honor pointed out, this was a collective bargaining agreement, but it's not. What it is guidelines. And I believe what this court has said and what O'Brien and Jackson and then the trial courts, the decisions that we cite, is the handbook can either be construed as guidelines that can be changed at any time, but they are guidelines, which can be helpful, or the handbook is a contract if you don't have the right disclaimer language. And this has that disclaimer language. And so it was used as guidelines, very consistent with the court's decision. I would also point out that we have two key other facts here that were not present in Ferguson, O'Brien, or Jackson. There was similar language in the employment application that the plaintiff said she read, understood, and signed, saying there are no promises at will. We can change at any time for any reason or let you go. And then at the start of her employment, she signed a conditions of employment document that had, again, the very same language. And I think that
It's an employee at will, and the handbook is not an implied contract or a contract. You put a lot of emphasis on her failure to use the grievance process. Why is that relevant if there's not a contract here?
Your Honor is absolutely right. It is not relevant if there is not a contract here. But if there were a contract, as we argue in the alternative in our brief, first, Big Y in no way failed to follow the terms of the progressive discipline policy. My brother made much of the counselings remain active for 12 months. I think Justice Ditkoff hit the nail on the head. There is nothing in these documents that says that just because it's now inactive after 12 months that it can't be considered. And in fact, the progressive discipline policy, record appendix page 181, expressly says that in general, the nature of the offense determines the appropriate level of counseling to be imposed. However, many factors are considered: the seriousness of the offense, the employee's past record. That goes to Justice Ditkoff's point about you may be off probation, it's no longer active, but it can be considered by a court at sentencing.
Was there any evidence in this record as to what that meant? I mean, it's fairly common in some workplaces to have discipline removed from a file after a year. But I don't know that I saw anything in this record that interpreted that phrase.
Well, in fact, there's the affidavit of Jamie Swenson, the employee relations, it's really human resources manager, who said, no, discipline stays in the file. That's number one.
Okay.
Number two, I think there is something in the record. At page 40 of our brief, we cite.
Oh, I'm not saying it wasn't there. I'm just saying I hadn't found it yet.
Oh, okay, very good.
I wanted to give you the chance to say if there was something.
I appreciate that. So I guess getting back to Justice Blake's question, number one, we believe the disclaimer language is such that there's no implied contract. Number two, even if there were an implied contract, Big Y followed the progressive discipline policy, and there was discretion expressly contained right in that policy to say we can move to any level of discipline, and that a factor that can be considered is the employee's past record, which is what was considered here, a record of numerous.
And you're saying Swenson's affidavit and something else at page 40 give meaning to that phrase?
Yes, I believe it does, Your Honor. And the other thing that gives meaning is the actual notice, the progressive discipline notice setting forth the reasons for her termination. It says, based on several complaints and concerns from store employees in May Street and in subordination to the store director, it has been determined that KRIS's management style continues to not reflect Big Y's firm foundations. Employees are continuing to not be supported in the way that Big Y expects. And then it goes back to her decision-making leave on 4/6/13, 2 years earlier. KRIS received a DML for the same concerns regarding treatment of employees in the Holden location and still has not corrected these issues. This is serious.
But before we go further into the particulars of this case, was there any countervailing evidence in the summary judgment record that to suggest that these that the discipline came out of the record after a year?
No, there's nothing.
Is there anything to create a dispute of fact? So you're saying that Big Y made its proffer, satisfied its burden, and that there's no dispute of fact on this record.
That is
As for the
correct, Your
1
Honor.
year.
Yes, and indeed, I think I know many of my colleagues on the plaintiff side of the employment bar who would object if they say you're removing items from an employee's personnel record. The personnel record is what it is. Now, I know it's, again, different in the union context as to whether things can be considered
Well,
here.
even in the non-union context, it would remain in the file, but it would be barred from consideration. But you're saying that you've established a record that shows the contrary, and we'll look at it.
I just want to make sure, to Justice Sullivan's point, at 137 in the Swenson affidavit, paragraph 10 says, inactive counseling records in an employee's file may be considered to determine if an employee has engaged in the same, similar, or repeated improper behavior over an extended period of time, et cetera, et cetera. And there's nothing in the summary judgment record to contradict that.
That is correct, Your Honor. And indeed, I point out the fact that there's also nothing in the record that talks about records are expunged or sealed, or there's nothing in the handbook about that at all. And there's express language saying that past record can be considered both in the progressive discipline policy and in the affidavit of Ms. Swenson, and that was undisputed, absolutely undisputed.
If it's not removed, but it can remain active for 12 months, what does that mean? What happens when it's active?
Well, I think what it meant is sort of like being on probation. I think Justice Ditkoff's analogy is good, that you are currently under sort of an active disciplinary measure because it's within the past 12 months. Once 12 months have gone by, the employee can, I would think, and again, the employee can interpret it as they want, but reasonably assume, well, I don't have an active discipline outstanding, so hopefully that'll go in my favor. So if we turn back to this case, again, not an implied contract, followed the express language of Ferguson. Even if it were found to be an implied contract, the progressive discipline policy itself gives very broad and wide discretion consistent with the at-will nature of the employment relationship. And then finally, Your Honors, on the peer review question that has been brought up, that is a grievance procedure. It is right in the handbook. And I would say this is exactly on all fours with O'Brien. It's in the record that Ms. England testified that she was generally aware there was a peer review process, even though she hadn't been through it before. She admitted she didn't ask for one 2 years earlier when she got her decision-making leave, although she could have, so she accepted her leave.
Do you disagree that what she committed was misconduct?
Well, Your Honor, that's interesting. Attorney Fletcher is pointing to testimony from the store manager that he felt it was misconduct, but the handbook is clear that the peer review was requested through the Employee Relations Department, and the Employee Relations Department, it's uncontradicted in Ms. Swenson's affidavit that had she asked for it, she would have been eligible for a peer review. But I respectfully submit, Your Honor, that even before that, let's say she had asked for it, and then Big Y said, no, we think that's misconduct, we're not going to give you a peer review. Then she would have satisfied her grievance, I would call it a grievance prerequisite to bringing a contract claim. But she didn't even bother to ask so that she could be told either, yes, you are eligible, as Ms. Swenson said, or perhaps, no, you're not eligible due to misconduct. But the fact that she didn't ask is fatal to her contract claim under O'Brien.
Well, so I guess I'm not following. Are you saying that even if it's misconduct, she has to go through peer review, or that it's clear this was not misconduct?
Well, no, I'm saying that it's not clear at all. Ms. Swenson says we would have given her a peer review. That's uncontradicted in the record, and she's in employee relations, and that's who you would have asked. My brother's pointing to the store manager saying, I think she was terminated for misconduct, but he's not the person running the peer review program. So I am saying, yes, she had to ask for a peer review, and she could have, because it wasn't clear whether she could or couldn't get one.
Hey, I guess I'm still on phone. You're saying that, are you saying that, I guess I'm not following. The contract says that any situation that involves harassment, violence, dishonesty, misconduct, or violation of the drug-free workplace program is not eligible to be resolved through the peer review process. I mean, the handbook, not the contract. So you're saying that creates a duty, even if it's misconduct, to ask for peer review, or that it's what I'm not.
Well, in fact, Ms. England says I did not engage in misconduct. So by her own testimony at her deposition, she didn't feel she'd engaged in misconduct. Certainly.
Well, but it's the employer's characterization that's going to rule when the employer decides whether or not to permit the grievance procedure to be invoked, right? I mean,
Right, and the word misconduct, I believe appears at all. It just talks about behavior and not improving and not treating the people that she managed with respect and being insubordinate. So at the very least, she could have and should have asked for a peer review consistent with the Supreme Judicial Court's instruction in O'Brien.
And you're saying that the affidavit said she was entitled.
Number one, and number two, she certainly was entitled to ask for a peer review, which she didn't even do. So under those circumstances, even if the handbook were a contract, she didn't avail herself of the peer review grievance process, and that's fatal under O'Brien. I will rest on my brief I see my time has expired, but we believe that the decision of the Superior Court should be affirmed on appeal, and thank you very much.
Thank you, counsel, both of you, for excellent arguments. The case is deemed submitted, and this is our last case and concludes our proceedings for today. We wish to thank once again all of the people who have made this sitting possible. The people in the clerk's office, our IT staff, law clerks, and